I, Prachi Bhardwaj, Senior Associate Editor, EBC, feel deeply honored to welcome you all on this momentous occasion where we gather together to release the book Corporate Insolvency, The Road to Viksit Bharat by Mr. Sumant Batra. It has been a remarkable 10 years since the introduction of the Insolvency and Bankruptcy Code, a legislation that has fundamentally transformed the landscape of corporate insolvency in India. We are thrilled to have you here for the launch of the latest edition of Mr. Batra's insightful work, which serves as an essential source that meticulously tracks the implementation of this landmark legislation, analyzes its successes and identifies areas that may require reform, proposes a roadmap for future advancements in the field. To mark this significant occasion, I would like to extend a warm welcome to all the distinguished dignitaries on and off the dais. Let me begin by welcoming all the dignitaries on the dais. It is my distinct pleasure to introduce our chief guest, Justice A.K. Sikri, a true legal luminary, a trailblazer whose contributions have left an indelible mark on the nation's justice system. With a remarkable career that spans over 4 decades, Justice Sikri has not only redefined the contours of constitutional law, but has also fervently championed labor rights and arbitration. As a former judge of the Supreme Court of India and currently serving as an international judge at the Singapore International Commercial Court, Justice Sikri's influence is profound and far-reaching. With more than 400 Supreme Court judgments to his credit, he is a beacon of integrity and a steadfast champion of justice. Sir, we are honored to have you as our chief guest today. It is my honor to now introduce Justice Ashok Bhushan, a distinguished legal mind and a dedicated public servant. During his 5 years as a Supreme Court judge, Justice Bhushan was renowned for a welfarist and humanistic approach in his judgments, reflecting a deep commitment to justice. While his landmark rulings have set major precedents that continue to shape the future of Indian jurisprudence, his dedication to ensuring justice during the challenging COVID-19 times speaks volumes about his integrity and commitment to the welfare of people. Since assuming the pivotal role of the Chairperson of National Company Law Appellate Tribunal in 2021, Justice Bhushan has continued to make significant contributions to the legal landscape of our country. We are honored to have you here with us, sir. It is a privilege to welcome our next guest of honor, Mr. Amitabh Kant, the former G20 Sherpa of India, who has recently joined Fairfax as a senior advisor. Having served as the CEO of NITI Aayog and the Secretary of the Department of Industrial Policy and Promotion, his leadership and vision have been instrumental in launching key initiatives such as Make in India, Incredible India, and Kerala, God's Own Country. His initiative with the Startup India movement led to India emerging as the third best ecosystem for startups globally, with over 70,000 startups and over 100 unicorns, and leading to India jumping 79 positions in ease of doing business indicators. With a distinguished career that spans over 4 decades, Mr. Kant has proven track record of driving transformative initiatives across India. We are privileged to have you here with us, sir. It is my pleasure to now introduce Mr. Sanjeev Sanyal, a distinguished member of Prime Minister Narendra Modi's Economic Advisory Council since 2022, where he holds the rank of Secretary in the Government of India. Prior to this role, he served as a Principal Economic Advisor to the Finance Minister for 5 years. Mr. Sanyal has represented India on several international platforms and has played a crucial role as co-chair of the G20's Framework Working Group. Since joining the government, he has been actively involved in numerous key reforms that have significantly shaped India's economic landscape. Notably, he was one of the key architects of the G20's Global Action Plan, which was instrumental in keeping the world economy functioning during the challenging pandemic years. We are honored to have you here with us, sir. It is now time to welcome the man of the moment, Mr. Sumant Batra. With 3 decades of global expertise in insolvency and bankruptcy, Mr. Batra is a distinguished figure in this field, being the only Indian honored with the title of International Fellow by the American College of Bankruptcy. He also holds a distinction of being the youngest and the first president of Insol International from Asia. With a private museum dedicated to rare and vintage Indian graphic art, a library to preserve interest in reading old and rare classics, and as the founder of the Indian Cinema Heritage Foundation, Mr. Batra is also a passionate advocate for India's rich heritage and literature. Each book by Mr. Batra brings his readers closer to the subject matter, and this one is no different. Thank you for giving EBC a chance to publish this book. Founded in 1942 by 2 visionary brothers, EBC has consistently been at the forefront of delivering high-quality legal resources to both professionals and students. In the ever-evolving legal landscape, EBC serves as a crucial link between the law and those it serves, fostering understanding and accessibility. It is my pleasure to invite Mr. Sumit Malik, Director EBC and Associate Editor SCC, to welcome the audience with his address.
Justice A.K. Sikri, Justice Ashok Bhushan, Mr. Amitabh Kant, Mr. Sanjeev Sanyal, Ms. Shisha Marla, and our author, Mr. Sumant Batra, learned senior advocates, students, and gentle people. It is my privilege and pleasure to welcome all of you to this event, where we will be celebrating the release of the book on corporate insolvency, The Road to Viksit Bharat. I am grateful to our chief guest and our guests of honor for taking the time out to participate in this event. Our association with Mr. Sumant Batra is now a long one. This is the 2nd edition of his book on corporate insolvency, the 1st edition of which was published in 2017. We've been closely associated with some of his earlier books, as well as his initiatives at the Insolvency Law Academy, which he so admirably marshals. The Insolvency Code is now 10 years old. The 1st edition of this book was written when the code was in its infancy. In the last 10 years, the Insolvency and Bankruptcy Code 2016 has significantly transformed India's insolvency regime and helped in speedier resolution, increased recoveries, behavioral change, improved credit culture, and a boost to FDI and ease of doing business. At the risk of repetition, I would like to say that in this new world of technology and artificial intelligence, ChatGPT, which allows for instant self-publishing and publishing on blogs, etc., the question is, how do we at EBC see ourselves? What is the role of a publisher? In today's context, I can say that we see ourselves as the trustees of the legacy of authors. We have, over the years, continued to preserve the legacy of our authors, names that are synonyms with teaching, studying, and the practice of law. Professor V.N. Shukla, Professor Kelkar, Dr. Avtar Singh, Professor Ahmed Siddiqui, Shri V.D. Mahajan, Shri V.G. Ramachandran, Professor T.K. Tope, Professor B.M. Gandhi, and others. In addition, it also means the publishing of material at the forefront of legal thought. A book, as I see it, is a custodian of thoughts and ideas. Judges, while deciding cases, are bound to decide the list before them based on a given set of facts and apply the law to those facts. Authors, when writing books, do not face such limitations. A good author will explain the law to their audience, but a great author will also show the light forward by sharing their thoughts and ideas in a book of what they believe the law ought to be. Sumant Batra's Corporate Insolvency does exactly that. Spanning 36 chapters and over 1400 pages, it is as comprehensive a work as one can find on the subject. The book masterfully brings out the economic role and the critical importance of insolvency law and how it dovetails in the larger economic and geopolitical vision of Bharat. The aspiration to become a developed nation rests on the foundation of the rule of law and a strong legal framework. This book, without doubt, makes a significant contribution towards building that foundation. It is with this spirit of custodianship, of nurturing and advancing the legal tradition, that we reflect on the evolution of our own publishing house. The changing landscape of law and technology challenges us, yet also inspires us to reaffirm our core mission to support the legal fraternity with resources that are not only current but also enduring. The book and platforms that we curate are meant to serve both as anchors to the wisdom of the past and beacons lighting the way for future innovation and reform. We recognize that our responsibilities grow with each passing year. With each new project, whether it is a comprehensive legal treatise or a cutting-edge digital tool, is undertaken with the awareness that it will become part of the daily life of practitioners, judges, students, and academics. The trust placed in us is both humbling and motivating. In an era where information is abundant, but discernment is rare, we strive to ensure that every publication bearing our name upholds the highest standards of scholarship and utility. This stewardship in our response to the faith reposed in us by generations of legal professionals and by authors whose legacies we are privileged to preserve. This philosophy of stewardship, balancing reverence for tradition with hunger for progress, runs deep within the fabric of our publishing house. The narratives of law, scholarship, and service are not merely preserved in the books we produce, but are actively shaped by choices we make as curators and innovators. Our journey is not only one of solitary achievement, rather it is woven from the collective efforts of generations, each building upon the foundation laid by those before them. As legal frameworks evolve, so too must the vessels that carry their wisdom. We recognize that the needs of the legal community, both timeless and ever-changing, demanding resources that are adaptive, authoritative, and accessible. To this end, we continue to invest in technology and talent, fostering collaborations that enrich our catalogs and expand the reach of our publications. Our mission is not solely to document the law, but to engage with it, interpreting, illuminating, and at times even challenging the doctrines that shape society. This sense of purpose is brought to life by the people behind our imprint, our authors, editors, researchers, and technologists, whose commitment to excellence ensures that every book, platform, and report is more than a product. It is a testament to the enduring values of inquiry, integrity, and public service. We believe that our role is to bridge the gap between legal information and knowledge and those who consume that legal information and knowledge. The journey of our publishing house is deeply interwoven with the history of legal India itself, a story marked by perseverance, adaptability, and a commitment to public good. Each page we publish echoes the countless hours invested by teams dedicated not only to accuracy, but also to the lasting relevance of their work. In this way, our catalog becomes not merely a collection of texts, but a living archive, a repository where legal evolution and collective memory find a home. And as the same is with Mr. Batra's book, and probably, I think, even till 3 days before it sort of went to print, this sort of continued, and we were sort of editing, finalizing it. Looking back on the decades of progress, we recognize that behind every milestone lies a spirit of humility and service. Our founders set forth not with grand resources, but with an unwavering dedication to the needs of their community. In that same dedication which drives us today, urging us to innovate, to reach wider audiences, and to nurture the next generation of legal minds. Our ethos is grounded in the belief that knowledge, once shared, multiplies in values. Every legal insight disseminated, every doctrine clarified, becomes a stepping stone for greater understanding and societal advancement. In the face of rapid technological change and shifting paradigms, our mission remains steadfast, to deliver content that is not only timely, but also timeless, not only informative, but transformative. We see ourselves not merely as publishers, but as custodians of a living discipline, charged not just with reflecting the present, but also shaping the future. As a third generation member of a publishing house, I am grateful for the guidance of my elders. Our story began in 1942 when my granduncle and grandfather, incidentally both from Jhang, and this is a sort of an interesting story. Mr. Batra, his next book is on the journey of a Jhangi, and that's what he's writing on. And I found this to be so incredible that we share the same heritage coming from a small little town which is now in Pakistan, which is where Sumant's family is from and the subject of his next book. The then humble booksellers served legal professionals, including the legendary Mr. Ambedkar. Their commission was and remains to provide resources that genuinely support practitioners. When EBC transitioned to publishing in 1947, our focus was on delivering high-quality, useful books for lawyers and students. The introduction of Supreme Court cases SCC in 1969, driven by a need for faster and more accurate reporting, further strengthened our reputation. Today, SCC continues to uphold its foundational principles of promptness, accuracy, and reliability, covering even the previously unreported judgments from 1950 to 1968. Recently, we launched High Court cases, HCC, to bring the same standard reporting to High Court judgments. With the addition of Company Law Institute to EBC, we now offer renowned journals like income tax reports, company cases, goods and service tax reporters in both print and digital formats. Innovation has always been part of our legacy. From pioneering legal research databases to CD-ROMs in 1990s, we've expanded to the SCC Online Web Edition, now hosting 20 terabytes of data and 6 million documents, over 300 plus judgments. While printed books remain vital, our EBC Reader platform offers over 400 ebooks, continually growing. Our online blog, SCC Times, reaches over 1.5 million views and 1 million visitors monthly, providing the legal community with timely analytical news. New ventures like EBC Learning, our online platform, and Mercury, a judgment tracking tool, are also gaining popularity. Through every evolution, EBC's mission remains to serve the legal community with trustworthy, innovative, and accessible resources. I am grateful to our dedicated EBC team, legal editors, engineers, DTP staff, proofreaders, and sales and marketing personnel whose commitment ensures our standards of quality and reliability. Special thanks to Ms. Nilofer Bhateja, our hardworking legal editor who worked on this book. Collaborating with Mr. Batra on this book has been a pleasure, and I look forward to future projects together. I also appreciate the efforts of Prachi, Shubhra, Sanchi, Sonali, and Vedehi in organizing today's event. Thank you. Jai Hind.
Thank you, Sumit sir. Before we proceed with the addresses, I would like to request all the dignitaries on the dais to please unveil Corporate Insolvency, The Road to Viksit Bharat by Mr. Sumant Batra. The road to Viksit Bharat clearly seems quite heavy, but surely worth taking. This occasion would feel incomplete without acknowledging late Shri Arun Jaitley, who, as India's finance minister, championed the landmark insolvency reform and heralded the enactment of the Insolvency and Bankruptcy Code in 2016. Mr. Sumant Batra has dedicated this book to him. I would now like to invite Justice Sikri to address the audience.
Thank you very much and good evening to all of you. My esteemed brothers, Justice Ashok, Bhushan, Amitabh, Kant, and Sanyal sitting on the dais. My very, very, very dear, I don't know, I should call him colleague, I should call him friend, I should call him my son or nephew. Like he wears so many hats, our relationship also has so many facets. And Mr. Sumit Malik, sitting on the dais, many distinguished senior advocates and other guests sitting off the dais, including Malik family, as well as Asha. It's really a momentous occasion, there's no doubt about it. And this book If you ask me to speak on this book for whole day, I can speak. There's so much to say about this book. It's really outstanding, but I have been given only 10 minutes. So whatever I'll try to say, you treat it as Gagar mein Sagar, and whatever message I'll try to convey as far as the merit of this book is concerned. IBC came as a legislation, everybody knows. It came after much hard work, right from 98, 99. There have been discussion of bringing a legislation on insolvency, giving away or shedding the archaic laws which were governed or which were governing the ecosystem of insolvency. Ultimately, as I think rightly, this book is dedicated to Mr. Arun Jaitley. When he was the finance minister, he took the lead immediately after assuming that charge and constituted this by Mr. Vishwanathan's committee, chaired by him. And in 2016, end of 2016, we saw the IBC coming into force. Everybody hailed, rightly so, that this is one of the best legislation, economic legislations which India has brought. And its results were also immediately seen. Our ease of doing business index, I think where we were at almost at the bottom at at a place 160 or 65, we within 1 year we are ranking rose to within 100. I think 99 or 100, and thereafter came down to 70. What I feel is, and that is the best thing in this book. I tell you, this, of course, any legislation which comes, any statute which is passed, its enforcement, when it takes place, naturally there are going to be commentaries. There are going to be various books written on that subject, whichever may be the legislation. And these commentaries may be giving the interpretation to various sections and how the courts have decided, etc., and all that you would see in that. This book is not confining its discussion to this aspect only. That is there, of course, to which I would allude to. But the main thrust of this book is, which is in the title itself, and that is what Sumant has been able to capture, and very few people would understand that or would have visualized about the IBC. It may be important legislation, economic legislation, etc. But what it is, corporate insolvency, the road to Viksit Bharat. This is one legislation which is an instrument to bring about economic growth in this country. That's the message which this book is giving, and the entire treatment of the law of various topics around this particular theme, which you can see from the introduction which he has given, even prologue before that which he has written of this book, where he has really stated as to why this is the catchword and why this is the theme of the IBC. It is again not the section-wise commentary, but various topics which are dealt with in last 9 years when the IBC, its enforcement is seen, and what are the issues which are faced and how these are to be dealt with. That is what is captured in this book. In fact, if I may say so here, that Mr. Batra, and it was told to you, and everybody knows here in this audience, and MC also told about this, that he wears many hats. He is a blend of, if I may say so, an academician, a scholar, a jurist on the one hand, and he has practical experience insofar as the field of insolvency is concerned. And his practical experience, I can say with sense of authority, although I'm no more a Supreme Court judge, but at least this verdict I can still give, and with sense of authority, and because what I'm going to say is correct. I think there is no parallel insofar as knowledge of insolvency law and the experience in insolvencies is concerned. There is no parallel to Mr. Batra in this country. They say we have marched together in this insolvency journey insofar as India is concerned. But of course, my constraint as judge, so I was only at the back door, and Mr. Sumant Batra went miles ahead. As you were told, this you were not told, let me tell you that when in 1999, around 98, I think, we established with the blessings of Justice Wadhwa, Insol India chapter of Insol International, which is an international organization. And you can see in 98, 99, when we did not have any such law and we were struggling. So he was chosen as secretary, and that also blessings of Mr. Arun Jaitley. That is why he always is thankful to him and owes a lot to him. But then from there, going to Insol representative, Indian representative in Insol International, and within few years, becoming president of Insol International, which is a international body. First from Asia, and the youngest president in Insol International. This is by no mean, and why I am emphasizing is that his experience, I'm now proving the statement, giving reasons in support of my judgment to that statement which I gave. And in the process, of course, not only he dealt with various kinds of insolvency issues in that international community when going shoulder to shoulder with those stalwarts. He had the first-hand experience. In the process, because of his brilliance, he was selected or chosen by World Bank, by Asian Development Bank in many projects which he undertook. Not only that, few countries came up to him, you help us in drafting our legislation in this country. So a person of that experience, and after this enactment and in last few years, the way in so many projects, so many policy projects of the government of India relating to insolvency, the way he has contributed, and he has been associated in so many committees constituted by the government. Mr. Sanyal knows it better, more than me, because he is in the this advisory committee, Prime Minister Economic Advisory Committee. He is a member there, so he has that knowledge. And therefore, the experience, all that experience which comes, coupled with, as I said earlier, the seeing this legislation as road to Viksit Bharat and giving that treatment to this book is phenomenal and totally different. One thing you may observe is that it is the second edition of this book. First edition was written by him immediately within 1 year of coming into force IBC. There were hardly any case law, as well as no commentary on various provisions, because the act has yet to be tested. And but then even at that nascent stage, his experience, and that is why I recounted that in great detail, and how this law should be perceived, how this law should be implemented, what should be the jurisprudential growth, and what are the legal principles enshrined in it which should take that shape. That is the message in his first book, which was within 8 or 9 months, as I said, of the IBC. And that again was his experience in the field. In last 9 10 years, 9 years now, we have seen the functioning of IBC and this journey of various ups and downs. One thing in the beginning of immediately after IBC, I must congratulate NCLT and NCLAT on the one hand, IBBI on the other hand. At that time, Mr. Dr. Sahu, who became the chairperson of IBBI, and Supreme Court. I think all worked in tandem. Otherwise, enforcement of laws and shaping of these laws, which even are brought by the legislation on our legislative book, is not that easy. It has various handicaps are encountered and various obstructions are encountered, and many times it takes years to even understand such laws through judicial means. But here was a cooperative efforts, as if nobody was talking to each other, but I think all these institutions understood that this is the law. If it is to be successful, it is an engine of growth, of economic growth of a country, and we have all to contribute. Yes, there have been number of progressive judgments. At the same time, let us be frank, there are few regressive judgments of the Supreme Court also. And this is not the stage to discuss all this, but then many other problems are encountered during this, particularly about the ethical issues of resolution professionals, delays in CIRP, etc. Let me frankly say here, Chairman, NCLAT is sitting, Mr. Bhushan. Of course, naturally, he is not responsible, or he also must be feeling about it. The manner in which many times NCLT members have been appointed has been a problem. And time has come when the persons have to be appointed keeping in view their domain expertise. They should have knowledge of economic laws in this country, because I have always felt that law and economics are greatly connected with each other. And the time has come when mediation in insolvency has also to take shape. Government has been doing a lot on this, and this book contains all these and much more. Because of my limited time, I would not say much, and but would recommend, this is the book which is to be read by not only the practitioners, not only the judges who have to give decisions, but by policymakers as well. And if you see, the book itself says law, yes, it discusses law, policy and practice. So what is the policy behind and how it can be implemented, various provisions, etc. And the jurisprudence which he has sought to create by this book is phenomenal, according to me. And I really congratulate him. I'll end by saying that all of you, I think I've forgotten the name of the author. There's a very celebrated book, What They Don't Teach You at Harvard. It is on management. And so what they don't teach you, one thing is how to manage time in a most constructive manner. And if you want to have those classes, come to Mr. Sumant Batra and ask him how he is able to utilize his time in so many activities. And it's not only legal books which he is writing novels, literature as well. He is busy in his cinematography, museums, etc., in those ventures also. And there are so many. I will not take time to elicit all this and count all this, but this is what he does, and whatever he does, it's not that it is on peripheral. It is with commitment, dedication, and putting his 100% into that particular venture, and this book is testimony of that. Thank you very much.
Thank you, Justice Sikri. I would now like to invite Justice Bhushan to deliver his address.
A very good evening to all of you. Justice A.K. Sikri, the chief guest of the function, Mr. Amitabh Kant, Mr. Sanjeev Sanyal, Sumit Malik, and the attraction of today's function, Mr. Sumant Batra, senior advocates present, members of the bar. I see all familiar faces who are involved with the insolvency adjudication, both in NCLAT, NCLAT, and the Supreme Court. And it is natural that they should be here in the launch of a book which is with regard to insolvency, its development and path shown by it. Other members of the bar, distinguished guests, ladies and gentlemen. I want to begin today by congratulating Mr. Sumant Batra on the occasion of the book launch event of the second edition of his book on insolvency titled Corporate Insolvency, The Road to Viksit Bharat, Law, Policy and Practice. It is a privilege and honor to be before this distinguished gathering of experts and eminent persons, all hailing from crucial and highly influential positions in their respective domain, and who have come together this evening to celebrate the success of Mr. Batra's phenomenal book. Today, amongst us, there are some seasoned experts of the insolvency law domain. These are people who have made tremendous contributions towards the development of the insolvency law in India, especially under the current insolvency law regime. The author of this remarkable book, Mr. Sumant Batra, began his legal career when he enrolled at the bar in 1989. In March 1994, he founded Kesar Das B and Associates, a law firm that would soon grow into one of India's most respected in the field of insolvency, restructuring and bankruptcy law. Mr. Batra led KDB as its managing partner. During his journey as a practitioner of law, Mr. Batra has been a fierce advocate both at the NCLT and NCLAT. In the late 1990s, he drafted the Charter of Insol India and affiliated it with Insol International, the leading global body for restructuring professionals. Mr. Batra has increasingly been called upon by global institutions. Over the last 2 decades, he has acted as a senior international consultant to IMF, World Bank, OECD and Asian Development Bank, advising on policy reforms across Africa, Eastern Europe, the Middle East and South Asia. He was instrumental in the design of legal framework, debt resolution system, and risk mitigation strategies. His efforts help countries build resilient financial system and put India on the map as a serious contributor to the evolving global insolvency regime. His passion for legal reform goes hand in hand with his commitment to education and scholarship. In addition to serving as an educator at law schools, he serves as the founder and president of the Insolvency Law Academy, India's first think tank focused exclusively on insolvency research and capacity building. In 2024, Mr. Batra received the Global Restructuring Review Award in London, becoming the first Indian to win the honor. He is also the only Indian international fellow of the American College of Bankruptcy, consistently rated as India's top insolvency lawyer by Legal 500. Mr. Batra continues to serve as a backend for those building careers in insolvency, restructuring and commercial law. In 2024, he co-edited Mediation in Insolvency, a game changer for Viksit Bharat, along with Justice A.K. Sikri, proposing mediation as a revolutionary tool in bankruptcy resolution. In 2017, Mr. Batra had successfully published the first edition of corporate law insolvency, The Way to Viksit Bharat, Law, Policy and Practice, the second edition of which is awaited and being launched today. It is an honor to walk you through the powerful structure of the book, Corporate Insolvency, a work that captures India's transformation in insolvency law. The book flows across three parts, each marking a turning point in our insolvency journey. Part 1 takes us back to the pre-2024-14 era, a time marked by bailouts, financial inefficiencies, and the urgent need for reform. It sets the stage for why the Insolvency and Bankruptcy Code became a necessity. Part 2, the soul of the book, covers the evolution of the IBC from 2014 to 24. It explains how institutions like the NCLAT, IBBI took shape, how corporate insolvency resolution, pre-pack framework, liquidation, and even individual insolvency have been tackled on the ground. And when we arrive at part 3, which cast a bold vision for the future, imagining India as a global insolvency hub in 2047, integrating ancient wisdom, global best practices, and modern innovation like hybrid models. Together, these three parts form more than just a legal narrative. They tell the story of India's maturing economy, its institutional grit, and its growing influence in global insolvency jurisprudence. The book is a timeline, a toolkit, and a forward looking vision for reformers, professionals, and policymakers alike. What makes this book remarkable is its relevance. It goes far beyond a standard legal commentary. It sparks meaningful conversation, offers practical solutions, and aims to inspire real positive change within our insolvency ecosystem. At the very heart of this book lies the Insolvency and Bankruptcy Code, or the IBC, a transformative framework that has fundamentally redefined how India addresses financial distress. The book thoughtfully chronicles the achievements of the IBC while also shining a light on critical next step needed to ensure it continues to deliver on its core objective, value maximization, economic revival, and credit discipline. Mr. Batra, the author of his important work, makes a powerful observation. I quote, "Insolvency should not be seen as a sign of failure. Rather, it should be embraced as an opportunity for restructuring, for recovery, and ultimately for renewal." A mindset like this is a key to fostering innovation, encouraging responsible risk taking, and ensuring stakeholders' protection when ventures fail. This brings us to a fundamental principle that Mr. Batra elaborates by stating the following, I quote, "One of the objectives behind the enactment of IBC was to consolidate the fragmented insolvency framework by creating a single law for insolvency and bankruptcy. It is through this process that old and inefficient systems gives way to new and dynamic enterprises. But for this to happen smoothly in a fast evolving nation like India, we must have a strong system in place to manage failures. A robust insolvency regime is not merely about resolving dispute. It is about giving second chances, building trust in our markets, and sustaining the entrepreneurship energy that fuels progress. The book makes a compelling case that IBC is not just a legal instrument, it is integral to India's grand aspiration of becoming a developed nation, Viksit Bharat in 2047. And let us be clear, reaching this goal will require nothing short of an economic leap from our current $3.7 trillion economy to nearly $40 trillion economy by 2047. Achieving this will mean scaling up per capita incomes, expanding manufacturing, and improving our business environment. None of this can happen without a fast, efficient, and trusted mechanism to resolve commercial disputes, and the IBC stands at the heart of that mechanism. If we are to preserve assets, restore business, and protect jobs, speed, and efficiency are non-negotiable. What makes this book an event more authoritative is Mr. Batra's rich background, his years of experience, his deep legal expertise, and his unique understanding of finance, governance, and public policy. His leadership is in both national reforms and international insolvency forums lends immense credibility and weight to the perspective he shares. One of the most insightful aspects of the book is his inclusive outlook. The book goes beyond corporate insolvency, examining issues like municipal insolvency, climate change, and unique challenges of MSMEs and individuals. This broad perspective highlights a major gap, the lack of a strong personal insolvency regime, which leaves many individuals and small businesses unprotected, ultimately hindering job creation, innovation, and youth entrepreneurship. Mr. Batra rightly argues that introducing a personal insolvency framework would unlock our demographic dividend. It would foster a more risk-tolerant, resilient economy and significantly boost investor confidence. Beyond analysis, the book offers a broader reflection on the evolution of insolvency law in India from its early days to its role today in building financial credibility and supporting national development. Mr. Batra places insolvency law in the larger context of India's growth story, showing how well designed legal frameworks can shape credit culture, improve governance, and reinforce market discipline. In doing so, this work is not just a retrospective, it offers a strategic roadmap for the future. It identifies what works, what needs to improve, and how we can build an insolvency system that is efficient, inclusive, fair, and future ready. In conclusion, this book is more than just a scholarly work, it is a guide, it is a call to action, it is a vision document. Since its inception, the journey of corporate insolvency resolution process has been remarkable. Between December 116 and December 1324, total of 2,707 CIRPs resulted in orders for liquidation. This figure is based on official analysis of insolvency cases under the IBC at the end of 2024. Out of the 8,175 CIRP cases admitted during this period, more than 6,100 cases have been closed. Recovery under IBC has been encouraging. Creditors have realized around rupees 3.55 lakh crores through resolution plans, exceeding 160% of the liquidation value and nearly 88% of fair value. However, average recovery against admitted claims remains modest at about 31 to 32%. Looking ahead, it is essential to recognize both the challenges and opportunities that future insolvency regime will encounter. The rise of globalization has led to an increase in cross-border insolvency cases, highlighting the need for harmonized international framework to resolve jurisprudential and creditor disputes. Although the unilateral model law offers a basis for such cooperation, its implementation remains uneven. Emerging trends such as pre-packed insolvency, out-of-court restructuring, and cross-border frameworks are making insolvency process more efficient and internationally aligned. As we pursue sustainable economic growth, it is important to recognize the value of mediation as a complementary tool in the insolvency resolution. Mr. Batra believes that, I quote, use of mediation in insolvency can be game changer for India in many ways. Excessive litigation by stakeholders before NCLAT can be reduced by using mediation to iron out the frictions. Mediation can expedite outcomes and maximize stakeholders' value through facilitated negotiation. While the Supreme Court has acknowledged its potential, wider acceptance among all parties is crucial for its success, as mediations enable mutually agreeable, party-driven solution. as we reflect on the insights shared today and the vision articulated in Mr. Batra's book, it is evident that India's insolvency journey is both a story of progress and a call to action. The IBC has set new benchmarks for how financial distress is addressed, but the road ahead demands even greater collaboration, innovation, and resolve from all of us. Mr. Batra's scholarship reminds us that effective law is not static. It evolves with the needs of society and the aspiration of the people. I commend Mr. Batra for this important contribution to advancing India's insolvency law in support of economic growth and national development. Let us build on this progress by embracing innovation, fostering dialogue, and strengthening trust among stakeholders. With continued commitment, India's insolvency framework can remain a model for others and pillar of our nation's growth. Looking ahead, the integration of technology and digital platform, as well as the inclusion of mediation and personal insolvency framework, will be crucial in shaping a more agile and inclusive system. In the words of the author, technology emerged as a powerful enabler, transforming insolvency framework and paving the way for faster, more transparent, and efficient processes that benefit all parties involved. We must also continue to nurture a culture where second chances are possible, where entrepreneurship is encouraged, and where the rule of law supports both economic ambition and social responsibility. In this spirit, let us move forward with renewed purposes, drawing on the wisdom of thought leaders like Mr. Batra and working collectively to ensure that India's insolvency regime remains dynamic, transparent, and equipped to meet the challenge of a rapidly evolving economy. With this thought, I end my address congratulating Mr. Batra for the printing of the second edition of this book and wishing him many more such achievements in the future. Thank you, Jai Hind.
Thank you, Justice Bhushan. I would now like to invite Mr. Kant to deliver his address.
The distinguished chief guest, Justice Sikri, the chairman of NCLAT, Justice Ashok Bhushan, my distinguished colleague, Sanjeev Sanyal, Mr. Sumant Batra, Sumit, all the distinguished guests, ladies and gentlemen. Let me at the outset first compliment Sumant Batra for a remarkable book. I have been very fortunate to write the afterword of this book, and I was truly honored to do this. Sumant is a remarkable person. He's an author, a great intellectual, a lawyer, a great cinema buff, all this rolled into one. So he's an exceptional human being, and much has been spoken about him. But his book is a work of great scholarship. I think it's one of the most remarkable books on this subject, with great amount of in-depth study by Sumant, and I think it's a must-read for anyone who's wants to make himself knowledgeable about India's growth and progress and the critical role which IBC has to play. I've been a long-term believer, and I've been associated with the drafting of the law when I was Secretary, Department of Industrial Policy and Promotion, and when we were working very hard to improve India's position on the ease of doing business. We jumped up almost 79 positions, a number of rules, regulations, procedures, all laws. Many of them were scrapped. India is the only country which has scrapped over 1,700 laws, but vast number of processes were digitized. But the need for insolvency and bankruptcy code was very, very critical. And that has ushered in a very transformative change in our financial ecosystem. The International Monetary Fund has actually termed IBC as a big bang reform in India, and the IBC has marked a very significant shift in India's transition from what was, India was once termed as a nation which was characterized as a nation with socialism without an entry to capitalism without an exit. And this paradigm actually shifted with the introduction of the IBC, which provided a much needed mechanism that is insolvency issues in a time-bound and very efficient manner. And the IBC actually, to my mind, has played a very transformative role in the Indian economy. At the time of its enactment, we were facing a twin balance sheet crisis where non-performing assets were hovering around close to 12%, and this resulted in the choking of fresh credit, which led to the economy stalling its economic growth. And the IBC actually emerged as a lighthouse of a new era, ushering in what Justice Nariman actually had eloquently paraphrased from John Milton, that defaulter's paradise was lost. And it engendered a culture of corporate accountability and credit discipline. Much has been said by Justice Sikri and much has been said by Justice Ashok Bhushan, but I would like to use this occasion to touch upon 4 critical points to my mind. Firstly is that there is a need to avoid reversal of resolution plans and upholding the commercial wisdom of the Committee of Creditors and engendering certainty, predictability, and the rule of law. I also feel that there is a need for establishing an office for the economic assessment of judicial decisions. And this is critical because on 2nd May 2025, the Supreme Court delivered a far-reaching judgment in the matter of Kalyani Transco versus Bhushan Power and Steel Limited. And actually, by directing the liquidation of BPSL, there has been several challenges. The court actually reversed one of the most elaborate resolution processes in India's insolvency history. And by undoing on rigid procedural grounds a long-drawn resolution process, where the Committee of Creditors had exercised its commercial wisdom, the verdict actually has introduced an element of huge uncertainty amongst investors. The primacy of the commercial wisdom of the COC had been established by a series of judgments, particularly by Justice Nariman, and those have been done. It is also likely to have spooked foreign investors who may be viewing India's insolvency regime now as commercially unattractive and less reliable than, and therefore less internationally competitive. Although on 26 May, the court ordered a status quo on BPSL's liquidation to allow JSW Steel to file a review petition, the episode actually raises critical questions on rule of law. The judgment and its fallout raises the profound question of the Supreme Court assessing and evaluating the economic impacts of its judgment. The court is the final arbiter of the Constitution. Its impact on economic issues is pervasive, and therefore, in addition to judicial deference, the judiciary should also conduct judicial impact assessments of its own judgments, both ex ante as well as ex post. And where possible, to resolve the economic impact of the court's judgment. This exercise is particularly important when it comes to matters of great economic importance, which are more often than not brought out by way of PILs. The Supreme Court is fully alive to this issue, and Justice Sikri in the Shiv Shakti Sugars judgment stated that in a situation where two views are possible, or wherever there is impact, I think the economic issue must take precedence over other issues. My view is that it's very, very important that if India is to become a $35 trillion economy, we must all be very clear that by 2047 that your GDP has to grow almost 10 times. Your per capita is to grow 9 times. Your manufacturing has to grow 16 times. And all this is very, very critical. The second point that I want to make is that there is a need for tribunal process reengineering. Justice delayed is justice denied, and it is essential to minimize judicial bandwidth on administrative matters while opening non-core functions to innovative, non-sovereign or private players to deploy technology for improved court management. And this I'm saying because I strongly feel that very distinguished judges are not great experts at management. And I believe that science and technology can solve pressing issues. We need to open our doors to the private sector and cutting-edge technology while carefully preserving the core of the sovereign judicial functions. For example, the privatization of passport seva kendras has resulted in a seamless process, and similar models could work for court processes. Innovations from global examples such as the autonomous His Majesty courts and tribunal services in the UK can guide us in transforming our judicial processes. And therefore, through investments of private capital and future-ready innovation, judicial process re-engineering could transform the administration of justice in India, and much like UPI, Aadhaar, etc., in which Supreme Court played a very key role, these can be built through the PPP model as public infrastructure. With cutting-edge technology as the cornerstone of these new institutions, the problem of arrears can be dramatically reduced, and the state can, it'll really drive efficiency. The third key issue I want to point out is on the ambiguity on key legal principles. And it is important to clarify the position on government dues following Rainbow case. The Rainbow Papers case, the VAT statutory priority versus IBC, the Committee of Creditors, which might include financial institutions and other financial creditors, cannot secure their own dues at the cost of statutory dues owed to the government or government authority, or for that matter, any other dues. This was a departure from IBC. On a plain reading, it appears that Rainbow Papers is at odds with one of the stated legislative intents behind IBC to accord a lower priority to government dues as against dues owed to secured lenders, banks, financial institutions, and this requires, to my mind, statutory amendment or reconsideration by a larger bench. The fourth point I want to make is that the legislative lacuna on cross-border insolvency. India has not yet adopted a cross-border insolvency framework, whether under the unilateral model law on cross-border insolvency framework or otherwise, and Section 234 and 235 of the IBC provide only for an enabling framework for cross-border insolvency, which is yet to be acted upon. To my mind, both Section 234 provides for bilateral or multilateral agreements to be entered into by the central government with other countries for purposes of cross-border insolvency, and Section 235 provides for a mechanism whereby the NCLAT can seek assistance from foreign countries. It is important to note that Indian law does provide for enforcement and recognition of foreign judgments on the basis of legislative reciprocity. I am of the view that it is very, very important that as India's economy integrates with the globe, given upcoming disruptions and redundancies on account of technology and climate change, which will lead to more insolvency, we need a model law for cross-border insolvency. So these are 4 key policy issues on which we need to really debate and discuss and arrive at a final perspective. Because if the country has to grow, if we need growth, if we need progress, if we need India to become a $35 plus trillion economy by 2047, IBC has to be the driving force. And it has to be the driving force for India's growth, progress, and prosperity. And Sumant Batra's book plays a very critical role in bringing many of these issues center stage. Thank you very much, ladies and gentlemen.
Thank you, Mr. Khan. I would now like to invite Mr. Sanyal to deliver his address.
On behalf of the various distinguished luminaries on the stage and distinguished guests in front of me, let me once more congratulate Sumant on a second edition of his remarkable book, which is already a Bible of sorts in this field. So congratulations to you. So as with the book, we have already heard a foreword from Justice Sikri, the body from Justice Bhushan, and you've heard an afterword from Mr. Amitabh Kant. So now the problem is, what am I supposed to do? So I decided that I shall do the next best thing and read the book for you from cover to cover. So let's start with chapter 1. Just kidding. This is a fat book, as you know. Now, there are 2 reasons I'm particularly pleased with this book. One is as an economist, and the other is as a historian. And both of them are important. So as an economist, let me say, this deals with an issue that is very, very important, which is the architecture of creative destruction. All economics is ultimately based on being able to create a culture of risk-taking, of entrepreneurship. And of course, it means some part of it will go wrong. And this is going to become even more important in an environment where technology is continuously churning, geopolitical systems are liquid, and all kinds of other shocks are going to come by. The only way you're going to succeed is by creating a system where the errors of continuous risk-taking are continuously cleaned up. So insolvency and bankruptcy are absolutely critical to the way we think of economics. And if you don't believe me, think about the alternative. It's the BIFR. Those of you will remember what it used to be. So this is something that is really critical. I was not personally involved in getting the law passed, but I was involved in using the law to do many things, not the least cleaning up the banking system while I was at the finance ministry. And during that time is when I got to know Sumant very well. And he and Dr. Sahu, who is not here, were very, very helpful to me in terms of helping me understand the nuances. And I have to say, it's a fine law that has been put together. So congratulations to all of you who are involved in that. And of course, to the subsequent enforcement of this and creating, of course, the whole case law and other things that didn't exist. So when the first edition of this book came out, none of all of that part existed. So in a sense, by writing the second part, I can say that many of the things that are here, I am actually personally witness to it. And I know that how important it is to put it all and document it. And here comes my hat as a historian. One of the major problems of a lot of Indian policy making, but generally Indian public life, is how poorly we document it all. Very often I come across some meeting will happen, great amount of debate and discussion will happen about some reform or some issue. And then I will discover, after much effort has gone into it, that exactly the same issue had been discussed with exactly the same arguments and debates some 20 years earlier, and nobody had bothered to put it all together. Because we don't have a system of institutional memory. So books like this are absolutely critical because in this field, in a sense, this book has now up to today brought us, the entire institutional memory of the system is here. And in a very important field. I wish there was more tradition of documentation in other parts of public life and policy making, because it would make it a lot easier for subsequent generations to understand what is it, why did earlier generations do what they did, what was the thinking behind it, and how changes were made, and how we ended up where we did. Now, so this book, therefore, I hope there will be, therefore, a third and fourth edition as well. And I hope to be here to be able to see its launch as well. So this, I hope, is not the last edition, but one of many more editions to come. Finally, let me say that in the time that I have known Sumant, he is a kindred spirit because, like him, I have many different interests. So they reflect also in the way he has written the book. So, of course, there is the serious stuff about the law and its implementation and so on. But he has gone back and dug up, for example, how did ancient Indians think about bankruptcy and insolvency? And he has also then speculated forward into an issue that I think is very important, and that is something that maybe some of us can take up, which is the issue of personal bankruptcy, individual bankruptcy. So that's something that's still a half-done thing, but nevertheless, well done, Sumant, and thank you very much.